10 seconds, 5 seconds. Start. The High Court, by the judgment which is under challenge in this appeal, confirmed the decree of divorce granted by the trial court, but only on the grounds of desertion, as the ground of cruelty was not pressed. It is apparent from the judgment of the High Court that the learned judge made various attempts to bring about a settlement between the parties but failed. This is noted by the learned judge that both the parties appear to be adamant regarding their respective stands, that is, the wife is not prepared to leave her job in Gujarat unless her husband is able to earn a handsome salary. Likewise, the husband is not willing to leave his present job and stay with the wife at Bhuj. It may be mentioned here the son of the parties is with the wife. The husband has made allegation that after the birth of the son, he had gone to the house of the wife, where he was not allowed to meet her, nor he was allowed to see his son. Likewise, the wife has made allegations that her mother-in-law had made dowry related demands from her. These are mere allegations and counter allegations on which reliance cannot be placed. Nothing of this kind was stated in the notices or replies thereto. The most important fact which emerges is that from 2nd June 1993, the parties have been staying separately, and there is total lack of any effort on their part to stay together. In this connection, the observation of the High Court is worth reproduction. Desertion means rejection by the party of all the obligations of marriage and permanent forsaking or abandonment of one spouse by the other without any reasonable cause and without the consent of the other. Unfortunately, all efforts to reunite them as husband and wife have failed. The marriage is completely broken down, and no useful purpose would be served by dismissing the second appeal. We are of the view that these observations of the High Court are fully justified in the facts of the present case. One has to particularly note the fact that the parties knew even prior to marriage whatever they were earning. The earnings of the wife from a government job before the marriage was more than double of that of the husband. With the knowledge of this fact, the parties entered into matrimonial alliance. The marriage survived only for a brief period of about 7 months. Since 2nd June 1993, there has been no attempt on the part of the wife to stay with the husband. She is a school teacher, and it is common knowledge that in schools there are long vacations during summer months. At least during those holidays, she could have visited the husband along with her husband and stayed with him. There is nothing on record to show that any such attempt was ever made by her. She has stated in her evidence that the husband used to come and stay with her during her vacations.